how this looks to Brooks, Broder, and Oliphant. David Brooks of the Weekly Standard, David Broder of the Washington Post, and Tom Oliphant of the Boston Globe. First, Tom, just in general terms, what was your impression of that hearing today?
I thought it was remarkable. If ever there were an argument for allowing television cameras in where Supreme Courts meet, whether it's federal or state, here you have it. Also, I thought the argument was very important because it enhanced the reputation of this Supreme Court, which is already considerable in the country in legal circles. But I think their careful questioning, their willingness to go really into detail and betray a very thorough understanding of the case already has enhanced their, at least, potential of delivering a decision that will provide a roadmap for the country. Now, they still have to do it, but I thought the hearing today was an excellent beginning.
David Brooks, an excellent beginning?
Yeah, I thought it was an outstanding day. Finally, somebody is in charge. We've had these weeks of partisans and spinners and hacks, all these people who would spin their grandmother out of the Thanksgiving turkey if that would help them win this election. And finally, somebody, and it seems the justices were grappling with the serious issues, not only who was going to win this election, but the long-term issues, the central issues of authority. Where does their authority come from? Where does the Secretary of State's authority come from? Where does the Florida legislature authority come from? So these were long-term issues, which were really a reassertion of some sense that somebody's in charge, that the whole process hasn't run out of control.
David Broder?
I've never seen these 7 men and women before, Jim, but it struck me that they are a very confident group. You didn't get any sense that they wished that this were not on their doorstep. They look to me like people who are prepared to take charge and to try to make some sense out of this real hash of a situation.
Do you acknowledge that they established, at least took a step today toward establishing a credibility, so when they do come up with a decision, that both sides will have trouble moving on from it?
Well, I think that's right, but it's also very clear that they are prepared to say and indeed assume that their word will not be the final word. What was really striking to me was that, beginning with the Chief Justice in his first question, they started working their way backward from that December 12th date when Florida is required to choose a set of electors to cast its 25 votes in the Electoral College. And they seem to assume that whatever the determination that they or the Secretary of State make, there will be further contest of that. So my impression is that they think we're going to go right up to that December 12th deadline before we get a final answer from Florida.
David Brooks?
For fair and balanced coverage. This is an NBC News special report. Battle for the White House. Here is Tom Brokaw.
Good morning, everyone. That is the now familiar facade of the Florida State Supreme Court in Tallahassee. And in that courtroom today represents the last best hope of Vice President Al Gore. His legal team will argue that a lower court was mistaken when it refused to admit disputed ballots already counted in Miami and Palm Beach counties, and when it also refused to review the ballots that have been filed with the court, the lower court, from Palm Beach County and also from Miami-Dade County. Let's go to NBC's David Bloom now, outside the Florida State Supreme Court. David, what can we expect today from the Vice President's legal team, and who will be representing both sides here?
Well, Tom, 30 minutes of arguments per side, interspersed, no doubt, with lots of questions from the justices. We'll hear first from David Boies. He is the lead attorney for Vice President Gore, prominent New York lawyer. Of course, he's expected to argue that Judge Sanders Saul, the trial court judge, ignored the best evidence in the case, those 13,000 disputed ballots from Miami-Dade and Palm Beach County. Then we'll hear from Barry Richard. He's the lead attorney for Governor Bush, prominent Tallahassee lawyer who's been hopscotching around the courts here in Tallahassee. The Bush team argues that Judge Saul's got it right, and that the best thing these 7 justices could do for the country would be to throw this case out and say this election is over. We could get a decision late today. Far more likely, we'll hear from the court tomorrow. Tom?
All right, thanks very much, NBC's David Bloom. Here in New York as well is NBC's Washington Bureau Chief Tim Russert. Tim, there is a political context to all of this as well. It really is the last stand for Vice President Al Gore?
Absolutely, Tom. Joe Lieberman went to the Democrats in Congress and said, give us a chance before the Florida Supreme Court. This is the chance. If the Vice President loses this appeal, there will be a watershed of Democrats calling on him to step aside, even though some of his staff and he himself, the Vice President, would like to hear the Seminole case decided. That's the FC ballots as well.
All right, thanks very much, NBC's Tim Russert. One of the leading election law experts in America is Professor Rick Pildes of the NYU Law School, visiting from the University of Michigan. Professor Pildes, what do you expect here today?
Tom, I think we're going to see a profound tension these judges are under between wanting to get the law right and the nearly overwhelming pressure of the calendar at this point. They may have some discomfort with some aspects of Judge Saul's ruling, but they are going to be acutely aware of the time pressure, and how they deal with that tension will be very interesting to see.
All right, thank you very much, Rick Pildes. Momentarily, we do expect the justice to file into that courtroom there. We should also tell you there are two other cases that are pending, the Seminole County case and the Martin County case. Gore lawyers and advocates of Gore's chances in Florida have filed suits saying that the Republican Party completed applications for absentee ballots and that that was an illegal act on their part. We may get a decision in those cases today as well.
The Supreme Court of the great state of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court.
Good morning and welcome once again to the Florida Supreme Court, where we'll have oral argument this morning in the case of Gore versus Harris. And as an introduction, as we did when we had oral argument in this court approximately 10 days ago in this case, we welcome the visitors here because of the...
Please, the court. My name is David Boies, and I represent the Vice President and Senator Lieberman.
Mr. Boies, let me start right off. You know, when the case was here previously in the protest part of the proceeding, no counsel for any party in briefs or in argument raised with this court the U.S. Supreme Court case of McPherson versus Blacker, seemingly because counsel did not believe that it was important for our consideration. However, that case was forcefully argued to the U.S. Supreme Court, and the U.S. Supreme Court has now called that case to this court's attention in the opinion that came out this Monday. And now, once again, no counsel has argued that case to this court, but I want to know from each counsel its importance here. My reading of that case is that the U.S. Supreme Court has said that the state legislature has plenary power, full power, in respect to appointment of presidential electors, and that power cannot be eroded even by the state constitution. Now, accepting that as controlling law, why does that not mean that the courts of this state can only be involved in resolving controversies and contests where the legislature explicitly gives this court that power, or a court that power, which it has not done in respect to presidential electors in 102.168. And secondly, even if 102.168 is read to implicitly apply to presidential electors, why is it not judicial review given to the circuit court and not this court, since the only means by which there is a right to appellate review in Florida is through the state constitution? Would you please address that? And I would